and an amendment has been drafted and is almost ready to be presented to Cabinet. Stakeholders, including the Attorney General's Office, the National Youth Council, the Dominica Christian Council, Social Welfare Division, the Bureau of Gender Affairs, the NGO Coalition, and legal consultant Ray Harris, were assigned the responsibility last October by the Minister of Justice, Immigration and National Security, Raymond Blackmore, to review the Sexual Offences Act dating back to the late 90s. Harris stated that one of their goals was to ensure that the group was not just one of talk, but one of action.
From the outset, we realized that no matter what recommendations we make, we wanted to ensure that our committee was not just a talk shop where we were going to make recommendations, but we were also going to make an effort to focus on the Sexual Offences Act to see in what way we could immediately recommend certain improvements to that particular law.
And some of the areas addressed in the amendment included an extension of the penalty for rape, especially in the more heinous cases, a provision for compensation to the families of rape victims, which is separate from what they may receive from civil suits, redefinition and extension of penalty for gross indecency, penalization for the sexual grooming of a minor, penalization for voyeurism, implementation of the mandatory reporting of suspected abuse of minors, among others. One submission that did not go past the first stage was the legalization of buggery. Attorney General Levi Peter said that the amendments will be presented to Cabinet and he expects that action will be taken shortly. He reiterated that there will remain reporting restrictions and the release of any information that may identify the victim or perpetrators in a sexual offense case is illegal.
Subsection 1 says, after a person is charged with an offense under this Act, any matter that is likely to lead members of the public to identify a person as the complainant or as the accused in relation to that charge shall not be published in a written publication or be broadcast in Dominica except A, where on the application of the complainant or the accused, the court directs that the effect of the restriction is to impose a substantial and unreasonable restriction on the reporting of proceedings, and that it is in the public interest to remove the restriction in respect to the applicant. Or B, in the case of the accused, after the person has been tried and convicted of the offense.
And Section 2 goes on to state the penalties for breaching that law. Peter said that the Act will continue to be reviewed and any other adjustments will be made in the future as the society continues to evolve and develop.